And while we're waiting for this news conference to begin, we're going to check in with Joshua Ritter. He's a legal expert. He joins us live to analyze what could happen next in this case. Thank you so much for joining us. So what do you think will happen today?
Well, I can't imagine that we're going to have all this fanfare. This is now the second press conference in about as many weeks' time without this being a pretty significant announcement. So I think that what we're going to hear is that George Gascón has agreed with the evidence presented to him through the defense in that habeas petition, and he's decided to go ahead and join with them in asking for a resentencing on both of the Menendez brothers.
And that's something that's critical, isn't it, Josh? I mean, you know, we've heard so many different people say this is the Gascón decision, but it's not. It's a judge's decision. But as you point out, when you have both sides of an argument coming before a judge saying this is what we'd like, that carries some weight with the judge, doesn't it?
Absolutely. You are correct. They're joining in a request of the court to have them resentenced, but ultimately a judge is going to have to make that decision based upon the motion, the facts, the law in front of that judge. But when you've got both the DA and the defense asking for the same thing, I think a judge would be hard-pressed to deny that.
Now, some people believe that District Attorney George Gascón's decision to reconsider this case could be influenced for political reasons, like wanting to show he cares about fairness in the justice system. Others might think he believes that perhaps this sentence was too harsh. What is your opinion on this? And especially since his opponent, Nathan Hochman, has not made any announcement about this.
I will say that I'm not a political strategist, but the timing of this is very interesting. The habeas where this new evidence was turned over to the DA's office, that was filed back early of 2023. So they've had this in their hands for some time, but it's now October before a November election in which we're hearing this announcement. So it's hard to say that it doesn't play any role, but you're absolutely right. We've changed culturally, certainly our view towards sexual assault as it relates to males being the victims of it. I think all of that has changed, and I think he's decided that their case deserves another look.
Well, let's talk about that if we can. We're still awaiting George Gascón to come in and make his announcement, but Joshua Ritter, a legal expert, is here with us. And Joshua, the thing that keeps coming back to me is, yes, we are in a different culture. And some 300 cases have been approached with Gascón about resentencing. But how do you retry a case, in essence, that is 35 years old? It was a deadlock. It was a hung jury, the first trial. Then there was a conviction. But now we're retrying it, in a sense, again. And many of the parties are not even with us anymore.
No, you're absolutely right. It isn't a retrial. It's essentially him using his power invested in him as the DA to request this of the court. Again, he doesn't have the out-and-out power to do it with the snap of his fingers, so he does have to get a court involved. But you're right. He is taking it upon himself to reevaluate this evidence. 30 years ago, a jury heard all of the evidence and decided that they were guilty of first-degree murder. Now, Mr. Gascón has decided that based upon, perhaps in part because of this new evidence, perhaps in part because of our change in views culturally, that he feels a more appropriate sentence would be manslaughter, if that's in fact what he's going to announce, which means they would already have credit for time served, which means the next order, if the judge grants this, the next order out of that judge's mouth will be to have them released.
I'm very curious if there are other precedents set that could influence this particular case in the Menendez brothers, particularly regarding like courts' view of mental health and childhood trauma and the long-term effects of childhood trauma.
The idea of requesting a resentencing is not entirely unheard of. It does happen. Usually it's based upon a change in the law. If there's been a change in the sentencing guidelines, perhaps someone can ask and petition the court to have them resentenced. But this idea of resentencing someone based almost purely on a publicity push, a social media groundswell of people saying, hey, they need another look. You know, you mentioned at the top of the story, the Netflix series, several documentaries have been done about this. And now this new habeas petition, I think it's kind of a perfect storm of efforts pushing towards this, but it's not entirely based on any kind of change in the law, just the change in the way they're viewing this case now 30 years later.
Well, and it is important to also say that while all of that is true, the Menendez brothers, the whole trial, it still rings for people. They remember it. But it is also important to note that, as you said, resentencing guidelines are a thing in California. And there are any number of people who might have been involved in a crime. They were involved in a crime where a murder was committed. They were found guilty of murder, but then those resentencing guidelines found them only guilty of, let's say, armed robbery. They weren't the person that pulled the trigger. Those people, too, have been released. So we are caught up in, and rightfully so, I think, the Menendez element of it. But this is going on across the state, isn't it?
Oh, absolutely. No, in every court across the state, they are hearing these types of hearings. My point is that they're usually hearing them based upon some sort of statute that you can point towards and say, listen, now under the current law, this person would not have been sentenced that way had this case been tried now with these sentencing guidelines that we have now in front of us. And we're asking, please, in the pursuit of justice, to resentence this person. Here, there really hasn't been a change. It's just, hey, let's look at this case through the lens of 2024. Let's look at back at a crime that was committed in 1989 in a different way. And in reevaluating that, do you think a more appropriate charge may have been manslaughter?
What kind of timeline can we expect once the judge gets this recommendation, if he does?
That's a great question, because this is a little unheard of. But I imagine if Gascón makes a recommendation today, they're going to have to file papers with the court. It's going to have to be put on the court's calendar. It's going to go back to that same trial court in which the trial was originally heard. The judge is no longer there. He's long since retired. They will have a hearing, and then a decision will be made by that judge. So it's not going to be overnight. We're not going to see footage of them walking out of prison anytime soon, but it could be a matter of weeks. It could be something that takes place before the end of the year.
And one of the things, too, is, as you're mentioning, it's not before a judge yet. So the wheels of justice can move very slowly. But am I not mistaken in one of the reasons we're so close to this happening is because at this point, Gascón is saying their behavior in prison has been such, it's been exemplary. They haven't even presented any new evidence, so to speak, that would say they've missentenced them. Right now, it's almost, we're looking at if they had manslaughter and they served this many years, they've done this thing. Am I right there? That much of what has been done right now is behavior in prison justifies these new actions?
You're right. That is a large part of the argument that their defense team is making, is that, listen, in the meantime, in this 30-some-odd years since they've been in prison, they've been exemplary prisoners and demonstrated it in many significant ways. But they're also saying the reason why they filed that habeas, which is actually separate and apart from what we're dealing with today, but that habeas is where they turned over this new evidence, which was a letter allegedly written by Erik to one of his cousins that was 8 months before the murders that talked about this abuse, and also a declaration from one of the members of the boy band Menudo, who talked about also being abused at the hands of Jose Menendez. And their request was based upon that evidence that wasn't available at the time of their trial. There may have been a different result. Now, what Gascón is saying is, I'm going to independently take a look at that evidence, and if I agree with it, then I'm going to request that they simply be resentenced and put this in front of a judge and say, we no longer feel that first-degree murder was the appropriate sentence or conviction at the time based on this new evidence. We're asking for them to be resentenced on manslaughter.
The interesting thing about what you're saying right there is that I would think that most prosecutors would say, no. I need to challenge that's coming from the defense, because you could argue a letter written in advance, because we were talking about first-degree murder at the time. It could show potential cover for premeditation. But in this case, the DA is not taking the adversarial side of that letter. The DA is taking almost the side of the defense, saying, if this is what's happening. Again, so much of this is in the front. Do you see what I'm saying with this? A DA that's got a different mindset could look at that letter also differently than the current DA is looking at it.
And a different DA could take a look at that letter and say, in spite of this letter and in spite of that declaration, the jury has spoken, and we should respect a conviction, a verdict handed down by a jury, and that shouldn't be overturned just because of this new evidence. And I will say too that I happen to know that even within that office, there's a lot of conflict. They're not entirely all in agreement with, if we're assuming he's going to make that decision, not all of the line deputies are in agreement that this is the correct decision. There are many people who were still in the office that were involved in that case, working in the office during the time that case was tried, who feel very strongly that the correct verdict was acquired back in the 90s.
How much influence does the family have? We heard recently, as early as last week, about from the sister of Kitty Menendez, the grandmother of
I think
Erik
that's
and
who we're
Lyle.
looking at
I think we're looking
here,
at the
yes,
grandmother
yeah.
right there. She was just being comforted just moments ago. How much of that public opinion and the family themselves saying that they believe these boys have had enough punishment?
I think that's really helpful for the defense's cause, obviously. To the sense that if they were opposed, if they were coming out strongly and saying, we don't even want to entertain this, this is a travesty and a miscarriage of justice, I think it would be very hard, both from a legal and certainly from a political standpoint, for the DA to come out against them. But they are all in favor, or not all, but a large portion of them, as we saw in that press conference, are very much in favor of this push towards resentencing. So I think that provides some, at least, cover from the perspective of the victims are also on board with this.
Well, we are looking at Mark Garagos now talking to the family, and we are continuing to wait a scheduled 1:30 press conference from George Gascón to announce what his intent is on this next step as it relates to the Menendez brothers. And again, Mark Garagos and Mr. Gascón have both said that they have been looking at this for almost a year and a half. Garagos had explained that they were aggressively looking at this for a year and a half. And Joshua, you mentioned that there is debate as to the path forward. I think that's just a common feeling for so many people. I don't know of anyone that I've spoken to on this who lived the trial, who remembers the trial, that's really adamant that they are certain as to what should happen with this.
I know, I think you're right. I think that is part of the reason why it is a case that continues to fascinate us decades later, is that you can still have some pretty strong debate about it. You know, I certainly understand their position as far as being victims of abuse and, you know, feeling like they had no other alternative. And then you get people who say things like, but yes, what about the mother? You know, if they were victims at the hands of their father, and that's horrible, and perhaps they acted in an unreasonable way under the circumstances, was the mother an innocent bystander? Why did she deserve to lose her life as well? I mean, it's hard. It's easy to forget too, I think, what a violent and horrible crime this was. They were shotgunned to death to the point that they had to reload to finish the job. So we're talking about a very, very serious murder. It was first degree. It was special circumstances, meaning it was eligible for the death penalty at the time. And now here we are 30 years later talking about perhaps a manslaughter and then being released from prison.
And that's one of the things that I keep coming back to, is it's almost a retrial of something that we're not really having a trial. We're just debating this resentencing and the change of culture, which takes me to the resentencing units that actually began in 2021 in the DA's office, when they really began to look at some 20,000 or so cases, maybe even more, where we're changing the sentencing guidelines. Is this case, does it fall into the resentencing unit? I mean, they're currently reviewing some 681 cases so far. They've released or resentenced some 300 people. So is this in that, or is this in and of itself a separate situation here?
This is really an entirely unique situation. There is a resentencing unit. There has always been a unit that takes a look at old convictions to see whether or not there was any kind of miscarriage of justice. Gascón and his administration has heavily pushed that agenda, the idea of reducing prison populations by looking at resentencing. To, you know, he's received some criticism for that. But this is really a unique situation, because this isn't, like I said, based upon some sort of change in the law or statute. It's merely based upon a reflection, taking a look back in hindsight at what occurred 30 years ago. Do we think we should look at this a little bit differently? They're going to point to some of that new evidence, but I really don't feel that that evidence is the driving force behind this. I really feel it's a change in the way that people view this case, along with just kind of this cultural push with, the documentaries and the Netflix series and everything else that seems to be really putting this case back in the cultural zeitgeist.
Well, it's interesting because ABC did that special, the Menendez brothers, monsters or victims, and they were talking about how they interviewed the jury when they came out and said none of them could believe that a man was capable of molestation, of molesting their own son. And since then, obviously, with the priest abuse cases and many other things coming out, public opinion certainly has changed, and also that boys were capable of being molested. But we used to not think that. So public opinion really has changed culturally as well. Do you think that has a big impact on this particular case?
No, you make an excellent point. I mean, it's easy to forget that they were mocked in the media back then. Their claims of abuse were ridiculed. I mean, on late night talk shows would make jokes about it. Saturday Night Live did skits about it, mocking them, telling these incredibly traumatic stories and crying in court. Regardless of how you feel about whether or not the verdict should stand, I think that we can certainly say that had that trial taken place today, you would not see that kind of response from popular culture in the way that you saw back then.
Well, and as we look at family members here, that is one of the most striking things is what you just said, and whether you can or can't believe them. The reaction of how we handled it back when it was going on and how we are looking at it now. When you have direct family members of the victim, I mean, we are talking about Kitty's sister because, Joshua, you pointed out, what about the mother? If the father was this monster, what about the mother? Why her? When the sister is one of those who are in the camp of the Menendez brothers, that is remarkable to me as not just a journalist, but as a person.
Right.
When Kitty's sister is involved in this effort, that speaks volumes, doesn't it? Even in the justice system, which is supposed to be, almost antiseptic, where you're just looking at the facts presented, that's pretty powerful.
Oh, it's incredibly powerful. Part of what the DA's office is supposed to do is pursue the interests of victims and protect victims. Well, here you have the victim saying, hey, we think they did something wrong, but we've also think that they've paid their price for it, that there was extenuating and mitigating circumstances, and that we should take another look at this, and that they've done their time. Whether you agree with that or not, it's hard to argue with the impact hearing from the victims, and not just a few, but a lot of them came forward to say that they all share in this view that they should be released.
Well, Joshua Ritter, again, is joining us as we await L.A. District Attorney George Gascón's decision. And again, we thought this was going to start right at 1:30. And for some reason, Joshua, could there be something going on right now? We've seen Mark Garagos there in the screen come and go. He continues to talk to Kitty's sister there, the family, who seems to be comforting. We feel like, I think you nailed it at the very beginning. Why would we be having another press conference if we didn't feel like to have a press conference now to say I'm not doing anything?
Exactly.
Strikes me as very strange. But why the delay, do you think? What legally? I don't want to try to get into the minds of anyone else. But could there be legal issues here that would cause a delay in this announcement here on a Thursday afternoon?
I don't know about legal issues, but I mean, to our point too, the fact that you have Garagos sitting there with the family members in the front row seats, I can't imagine they're putting this thing all together, like you said, to disappoint all of them with an announcement that isn't favorable to their cause. As far as why we're sitting here delayed, I think that's anyone's guess, but I don't think that it's because of some sort of last minute, petition by some other interested party to somehow delay this, because as of this point, nothing has been filed. So I imagine what we're going to hear today is his intention to actually file something. As far as I know, there has not been a legal document entered into the court system by the Gascón administration in regards to this case just yet.
And what we understand is DA Gascón really wants to push this through. If he goes through with it, he's talking about a release as early as before Thanksgiving.
How could that happen legally? I mean, could it happen legally?
I mean, there's no kind of statutorial guidelines as far as how long or how quickly it could happen. It really depends on getting the case in front of a court, which is, sometimes as simple as calling the court and asking for when their next available date that they have to have this heard and filing their motions. It would be interesting to see if there's some sort of amicus filed by another party in opposition to that. Not unheard of. But eventually this will end up in front of a court. There's no reason to delay it. That judge may want to review the law to make sure that they're not just acting out of, emotion based upon the pursuit by both the DA's office and the defense, that there is some sort of legal precedent and ability that they have to do this. But, short of all of that, it's just a matter of a judge making an order. So it could move pretty rapidly.
And to that end,
November, Thanksgiving's not outside of the realm of possible.
Okay. To that end, I have spoken with and done a story with a person who was resentenced, had been life without parole, and within weeks went from feeling like he was in prison for the rest of his life to living on a college campus, finishing his degree. It was that fast. Is that what we're looking at here potentially? Once the judge makes a decision, you're out? Or will there be some paperwork, some mechanisms that have to take place from being in prison, thinking I'm there forever, to out? I mean, it's happened already. Is that something that could happen here?
I mean, you make the point that the judicial system seems to move at a glacial pace, but putting aside any sort of, unforeseen legal interference, it could move that quickly. I mean, it is a matter of just a judge making an order. If this sits in front of a judge and the judge decides, I'm going to go ahead and resentence them, that can take place that afternoon. And once that order is entered, they will receive credit for the time that they've already served, which is more than enough to have satisfied a manslaughter conviction in this case. And then at that point, the state of California has no ability to continue to hold them any longer. A judge will make an order, and it could be, I don't know if there's some sort of health standards and safety checks that have to be done inside of the prison system, but there isn't really any reason to delay this. It could move very quickly once that order is made by the judge.
We should note that not all of the family, the Menendez brothers, do want them out early.
Exactly.
I believe it was Kitty's brother also. He was opposed to it. So how much say and how will he have to weigh which family members and how many people want him out, and the family members versus the ones that want him to stay? Is it just
the California has a Victims' Bill of Rights, Marcy's Law, that any victim, family member can be heard. So there could be an opportunity for those family members who are opposed to hire their own counsel or independently file something to request to be heard by the court. So there could be a hearing where we could hear opposition to all of this, and a judge is going to have to weigh that. So it's not that this will be done without their voices being heard or considered. It's just that as far as a legal mechanism to delay this, there's nothing that's coming to my mind as I sit here.
Well, I think that's a very valid point, because we are right now hearing the people who are most interested in this particular outcome as we potentially think it's going to go. But 100% right. There are people who don't believe them,
right,
who thought that this was a completely different thing and are more than satisfied. But again, it's a very interesting thing in that, okay, so how would that side of the argument be heard legally? If Gascon, is that going to be at the hearing? Whatever hearing might come forward, they might say, hey, I want to speak?
Yeah, absolutely. And then they will be afforded that opportunity, absolutely, to be heard, as victims are afforded that opportunity at any hearing in the criminal justice system. I think a point should be made, too, that, the judicial system and judges, they favor upholding verdicts. I mean, we want there to be finality in our judicial system. We want a trial to take place, 12 people to decide, a verdict to be handed down, and for that to be the end of the story. And in rare cases where there was some sort of miscarriage or there's appealable issues, you can understand why that might be overturned. But for the most part, just simply 30 years later saying, we don't like this anymore, we've changed our minds or the ways that we view this, usually not the standard to request something like this. So there is not entirely a precedent for doing this, and there is a favor towards upholding verdicts. So I'm not saying this is an easily done thing, but again, if you have both the DA's office and the defense and victims' family members all favoring this, you could see how it could easily go their way.
Well, Joshua, I'm getting word that Kitty's brother actually might be filing an amicus brief. So if he does that, how does that play into what we're doing now?
That would be heard during that same, like I said, it's going to go in front of a judge.
So that's basically a formality that would have already been done.
That may cause a little bit of delay, in that the judge may want to have, afford people opportunity to be heard in argument. It may cause the judge to do a little bit more research. But again, these types of hearings are heard all the time, where there are opposing sides to all of this, and decisions are made every single day. So I'm not surprised to hear that something like that may occur, but I don't think we're talking about a delay, pushing us back several months. It may keep us on the same timeline.
Could it possibly delay Gascón from making this announcement today, or is that just behind the scenes?
I imagine that those folks who are opposed to this have been aware that this was in the works for a while, and they've probably made those objections, if not formally, at least informally, to him through their representatives. I'm guessing that if he's decided to call this press conference, he's heard that opposition and weighed his decision before going ahead and taking this podium.
Well, it does go to what Ellen said. When I find it fascinating that the sister is in support of the niece and the nephews, that there is another side to this. And in families, we all can have disagreements. And so in this particular family, and you can imagine with something of this magnitude, they're all not going to agree to the same thing. And I would think that that's another reason why it took Gascón a year and a half of engagement with Garagos and the Menendez brothers to come to whatever decision we're awaiting.
Yeah, no, absolutely. And I should say, too, for people to understand, this is really the last of the last-ditch efforts that they have at all of this, because they've appealed this case before and been denied. They've exhausted all of their appeals. One of the hurdles you have to satisfy in order to even file a habeas is to show that you've exhausted all other avenues of appeal. So when they filed that habeas last year, it was really their last-ditch opportunity. Now, this is something kind of a unique add-on, but being denied this here, if that's what Gascón announces, I really do feel that is the end of the road for these two men.
Wow. Well, can you paint a picture for us? So would it be like any type of resentencing phase of a trial? They would have impact statements from all those involved that are still alive?
I think that would be wrapped up in the entire hearing as part of the victims being heard on even the decision to do this. You're right, a resentencing hearing would actually take place as well. But when we're talking about resentencing someone from first-degree murder to manslaughter, we already kind of know what those guidelines are. And even at the far end of the guidelines for manslaughter, I think they've already served enough time. So it's not a matter of a judge even picking a number within that sentencing range on the manslaughter. They would most likely have satisfied all of this as far as the time that they've already served. And it would be just a matter of, do they get sentenced to that? And when does he actually order their release?
Joshua, if I could, and I'm just getting this, so I'm just going to read it for us. It is a statement from the victim's rights attorney who is working with Milton Anderson. He is the 90-year-old who has what they call endured unimaginable loss of his sister, Kitty Menendez. So this is a statement, and he's saying in this statement, despite numerous requests, Gascón has refused to inform Mr. Anderson of any decisions before holding press conferences. Mr. Anderson has been left in the dark, forced to learn crucial updates about his sister's case through the media rather than being treated with the dignity and respect he deserves. Now, I'm just reading this out. We have a media contact, which I will not name, but that is apparently coming from the brother of Kitty Menendez, who is claiming in this statement they're dismissing the crucial evidence ahead of the election. And the thing, Joshua, that strikes me on that is apparently Mr. Anderson is deeply upset that he's, what they're saying, been left in the dark about these decisions. Meantime, you have Mark Garagos and Joanne Anderson there, the sister, who seem to be intimately involved in the process. So there is some back and forth here that doesn't seem to be what you would like to see with something like this, where everybody is talking and we're trying to come to the right decision. If Mr. Anderson is telling us the full story, he's being left out of this.
No, you're absolutely right. If that is true, that is really unfortunate, because that really is not the way that the DA should be handling this type of a case of this magnitude, this much media attention, this degree of sensitivity. The DA's office is used to making incredibly difficult decisions that affect a lot of people's lives. And many times those decisions are not easy, and many times those decisions do disappoint people. But part of doing the job is informing those people and letting them know that in spite of their requests, the DA's office feels it's in the interest of justice to pursue a different path. And you would have hoped that certainly in a case like this, that would have occurred. So if that is true, that's really unfortunate. Now, how will that affect things moving forward? Probably not a lot as far as what Gascón is going to decide today, but when it does get in front of a judge, they will get an opportunity. They have California gives them a legal opportunity to be heard and considered by the judge before the judge, who actually will be the ultimate decision maker on this whole thing.
Well, we have just taken a look at the amicus brief. It was signed by Kathy Cady. She's the victim's rights attorney, retired deputy district attorney. Not being a legal expert, I don't even really know, to be honest with you, Joshua, what to look for, other than this is an application to file an amicus brief, habeas claim. So much of what you're saying, and then it's a long, lengthy brief here that they are filing, and it does look as if it was a confirmed copy October 23rd. So today's date is October
It's today's date.
24th.
So if this was filed yesterday, that really wouldn't matter with Gascón's decision today, or could it potentially make him be rethinking what he's doing?
I guess my point is that his decision today is merely him declaring his intent on what he intends to argue in court. His decision today really doesn't have an effect on the Menendez brothers' future. I mean, it does in the sense that it will obviously be viewed as a win for them if he supports their release, but he is not the final decision maker. So the DA taking a position on this that's adverse to one of the family members who's filed an intent to file an amicus, I think that what that means for us is that it's not entirely going to be smooth sailing from here on out, but the same procedure will take place. They will file a request of the court for a resentencing hearing. A resentencing hearing will be calendared with the trial court. A date will be set for the arguments on that, and eventually a judge is going to have to make a decision. And all of those steps could happen with, alacrity within the next, month or two.
So this sounds more like a formality, not any legal binding thing that an announcement would be made today. It just his intent to file or to recommend to the judge.
It doesn't prevent him from making his announcement today.
Which I just look at the room. I'm just trying to read and see if we see anything from this room that might indicate that Gascón is coming out anytime soon. And we continue to see Garagos leave and come back. We have a new party that has come in and sat down next to the sister. But Joshua, I keep coming back to what you said earlier, that the court likes to respect the decision of a jury. And when I come to this amicus brief filed by Mr. Anderson, you start to wonder, okay, in front of a judge, we now, earlier we said when the prosecutor and when the defense come before the judge and ask for the same thing, well, the judge is probably going to go with that. But we don't have that if this amicus brief is happening. And so to that end, for people wondering what might happen, it is important to note what you just said. The judge is going to probably lean in the direction of siding with what the jury said. And when you have these parties now arguing this case in front of this judge at a date in the near future, the smooth sailing comment, I think, is right on the money. Many people just think this is going to happen just because it's being announced maybe today. That doesn't appear to be the case. It does seem to be there might be a bit of a battle here.
You're absolutely right. The overturning a verdict is no small task at all. It's no small ask of a court at all. Judges are very concerned with something called precedent. They want to make sure that what they're doing is not somehow setting a precedent, because you can think if this was as easy as it was, just having a documentary made, getting some people together, appealing to everyone's emotions and feelings of nostalgia about a case that took place 30 years ago, and then just saying we don't really have a legal basis, but it's more of an emotional plea to have our verdict overturned, the courts would be flooded with these types of requests. So certainly the judge is going to be very concerned with what kind of a precedent is being set if they go ahead and decide to make this decision. Now, obviously, takes some of the pressure off of the judge when the DA's office is pursuing it and the DA's office is saying, listen, this is based upon new evidence. With this new evidence, we've taken a different look. Had we had this evidence back at the time, we may not have filed the case the way that we filed it. It's not a lost argument, but it's still, to your point, no small undertaking to say we want to overturn a jury verdict. It's one of the things that we need to respect more than anything in our criminal justice system, is that a jury's verdict should be final.
Come to this, and is there any precedent with some type of case like this?
Well, when you're talking about a case where and I'm not trying to oversimplify it, but when you're talking about a case where the lion's share of their plea has to do with, we think it's fair, essentially a plea to emotion and fairness and changed cultural views, I can't think of something like that in recent memory. The idea that, hey, laws have changed. If they were making a plea that this case would not have been filed that way under our current laws nowadays, that would be a very different argument. But their argument is really, they've been model prisoners. They did suffer abuse. We look at abuse differently today. Again, I'm not trying to oversimplify or belittle their arguments, but they are saying there is other evidence. But I think really their plea is that we have changed a lot, and certainly Gascón highlighted that the view towards abuse, victims of abuse, how we view people who react to that type of abuse, and certainly males being the victims of abuse has changed a lot, that we may have viewed this case differently today. Yeah,
we certainly have learned so much about the effects of trauma and long-term effects, and perhaps what would make somebody act a certain way after the trauma.
1,000%. And by the way, when we talk about this with a potential new DA, however the election results, that Nathan Hochman has not made a public announcement about what he wants to do here if he were in office. But a question to you, Joshua, from a colleague. If there is an election and this decision has not been made, but it's made somewhere in the interim before a new DA takes over, what is the logistical element of that? Is it much like a presidential election where he's in office until a new person is inaugurated? So many things can happen in the interim. What happens in that circumstance if a new DA comes on and they do have a different opinion? And again, Nathan Hochman has not weighed in on this, so I'm not trying to put words in his mouth. How does that go?
I think the legal term for it would be a mess, because it would be something sitting in his lap. Now, if the DA's office actually files a document, makes an argument, submits and files that to the court, the hearing is heard under a new administration who takes an opposite view to that. Yeah, that would be a problem. And because that DA has his own edict, he has his own feelings. He's been voted in, and he has different views on how this case should be handled. I see that Gascón's walked in now.
Yes.
Just
long
shook
story
hands with
short,
the sister.
I think it could be a mess.
Okay.
Okay.
Thank you, Joshua.
You have been wonderful, Joshua. Thank you so much.
Absolutely.